to be present with you when you're having communications. Again, if you look at the evidence code, under the evidence code, you may communicate with an agent of the client if the purpose of that communication is to further the client's interests. It doesn't state in the statute that there's any particular limitation on who that agent can be. But when you have your first communication, you want to make a record, but you first want to make sure that your client understands. Please make sure that you observe the confidentiality of our attorney-client communications. Do not share with others what I'm advising you or our communications, because then you may waive the privilege. So please don't discuss our confidential communications freely with others in your life, even if they're close to you. But if you need someone to assist you, yes, I can work with you, and then you want to also explain to that person what is the attorney-client privilege, what communications are covered by the privilege, and how important it is for that person not to go out and discuss with others what was discussed during this, under the umbrella, so to speak, of the attorney-client privilege. Yes?
I have a question. If you, let's say your client wants you to file a motion for them, and it contains information that's not credible, that you've tried to verify and you know it is not credible, and you confront them with them, and they're like, no, it is, or they still are insistent about wanting to present the evidence. And let's say you go along with that, and at some point the state bar inquires with you, because maybe that person made a complaint about you, and they inquire with you. What are you allowed to tell that investigator from the state bar about why you wouldn't do something on that motion, or the fact that you had some information that led you to believe that your client's just lying and you don't want to present that?
Okay, so again, the question is, what happens when the client is asking you to submit something to the court on their behalf, and you have grave reservations about the accuracy of the information that they're providing you, and you either do or don't include that information? Then what happens if there's a complaint by the client? Are you free to reveal to either the state bar or in some other context the client's statements to you and why you concluded that the client was not being truthful? First of all, again, it's a difficult situation. We as lawyers don't have an absolute ethical obligation to go out and investigate the truthfulness of what a client is telling you, as long as we're reasonable. So if a reasonable lawyer can look at this information that the client is providing and say, I'm not the judge, and I'm not the trier of fact in this case, I'm not sure we're going to prevail on this, and I'm not sure whether it's going to be deemed to be the strongest evidence, but I'm not convinced that the client is committing perjury or telling a complete falsehood. You don't have a duty to go out and be the determiner of the facts. Again, if you have a reasonable expectation that the client's not being truthful, you have a concern, you cannot suborn perjury, that's a different situation. And also be aware that if the court finds that the lawyer knowingly put forward false evidence to the court, you could be sanctioned, and or the court could refer you to the state bar for investigation. So you could be called upon to respond to why you took that role in presenting that evidence to the court. Generally speaking, if a client makes a complaint against a lawyer, the client waives attorney-client privilege so that the lawyer can respond. You can't go beyond the scope. So I'll give you an example. Lawyers have been disciplined, and it's pretty well accepted everywhere in the country. Let's say your client tells you as part of the representation that the client has a prior felony conviction. And the client wants you to know this. It's not necessarily relevant to the case, and let's say that you're never called upon to reveal that. Client's never asked, and it never comes to light. If later the client makes a complaint against you, and I know that you guys are a little bit different because you probably don't get sued civilly for malpractice very often, but in the case where, for example, a lawyer does get sued civilly, the lawyer cannot reveal any information which the client told the lawyer in confidence, or which the client knows or should know is a client, sorry, the lawyer knows is a client's secret, because under Business and Professions Code section 6068E, we have a duty. It's more than just the evidentiary privilege under the evidence code. We have an actual ethical duty to maintain client secrets. So even though the information that the client has a felony conviction is public information, and even though somebody who knew where to look or thought to look would be able to find that information, it doesn't obviate the lawyer's ethical duty to maintain it in confidence and to hold it secret, even if the client has some other beef against the lawyer. So yes, you can respond with information that the client told you that's pertinent to the claim that's being made against you, but keep in mind you cannot reveal other secrets which are not pertinent to the claim of breach of duty that the client is making against the lawyer. Yes.
Could I go to hypo 2 again for a second?
Yes.
And change it slightly. So instead of the client setting us up and telling us they're going to commit a crime, we're in an ongoing trial. The client is sitting listening to us cross-examine the social worker. That's the person who they met with at the TDM meeting. The social worker, so to speak, is misstating the evidence. And the client takes you aside at the break and says, the social worker is lying. I need you to cross-examine them on that. And you say, well, how do you know that? What can you help me with in the way of information that will help you cross-examine the social worker? Say, well, I take the TDM, and at the TDM they said dot, dot, dot. They've now provided you with information that's pertinent to you being able to be an effective, zealous advocate, which you understand was acquired possibly illegally. Do you have any problem with using that evidence?
Okay, so again, the question is, what happens when after the TDM is gone in the past, and you're now at trial in the middle of cross-examination of the social worker, the client pulls you aside and says that social worker's testimony is lying, it's not true, she's lying, and you say, how do you know? And the client says, because I taped the TDM. It seems to me, now first of all, as I say, I haven't researched whether in fact taping at a TDM is a crime, but we're assuming it is because it was a secret tape recording that was not consented to. It seems to me that the lawyer, because it's a past bad act, now has a duty to keep it in confidence, and you probably can't use it because it was obtained, fruit of the poisonous tree, kind of, obtained illegally. But the client was there, and the client can testify that's not what happened. So it seems to me that you can use the client's testimony and not, so to speak, throw the client under the bus by spontaneously volunteering that the client taped the TDM. My analysis would be it's a past act. You are not, there's no way to continue the bad act because it's already occurred, and you're not going to be able to advise the client to correct it. It's not correctable. So I think the way you would handle that is by considering that to be a confidential communication of a past bad act. You have to maintain its confidence, and you deal with the information just as you would have if the client had said, I was there, I heard what happened, what the social worker is saying is not true.
So, for example, then the tape recording is only an outside validation of the client's statement to me of their recipient witness experience. Therefore, I can use the information to inform my cross-examination of the social worker, which might be a more effective tactic than putting up the witness who might be dispensed with as having an axe to grind and therefore not believable. Whereas I can use it in cross and possibly be quite effective.
Well, again, I would suggest that you research it, because I have not researched whether there are any exceptions to what would be the typical rule under the penal code of secretly tape recording someone. There's a whole body of law on reasonable expectation of privacy, and when people are deemed to have consented to having their information taped. I don't know as a matter of practice if you've seen that happen. I'd want to research it and see if you think that you can make an argument on the law, and maybe there's case law in California that stands for the proposition that a citizen involved in these types of proceedings have the ability to tape them, and that everyone who participates reasonably expects that maybe they will be recorded, then I think you'd have an argument. The other alternative would be to go ahead and use it after having explained to your client, you may face referral to law enforcement and to criminal prosecution if we use this tape. And you have to make an informed decision, and I advise you to seek independent legal advice from a criminal defense lawyer if you think you'd rather take the risk of facing criminal charges for having secretly taped this meeting, and then I can use the tape, which will be more persuasive to the trier of fact than if you just get up and testify. But I think it's something that you, number one, you have to analyze it, you need to research it, and you need to make sure you have informed consent from your client.
Let's move on to the next one. So we can
Okay,
continue.
moving on to the next typo. Well, I think we sort of covered number 3 in a way. You find out after the fact that your client has already submitted a completion certificate which contains false information. You know, this is a situation where, in my view, in order to continue or complete representation of the client, you're going to have to use that information. And you only have 2 choices. One is the client has to correct it, and then you can continue to represent the client. If the client's going to seek to perpetuate this false information that's being used in a judicial proceeding, and you cannot persuade the client not to do it, you have to declare a conflict and you need to withdraw, because you may not assist the client in suborning perjury or continuing to submit false, untrue information to the court. Those are your 2 choices.
May I follow up on that?
Yes.
Wouldn't that be continuing a fraud upon the court?
Well, what I'm saying is, if the client didn't correct it, I think it would be a fraud upon the court. But if the client corrects it, I mean, this happens to me all the time in my practice. I represent bar applicants who have submitted a moral character application to the Committee of Bar Examiners, and they either neglected to include information, like a DUI, for example, or in some cases they just forgot. I mean, they forgot that back in college, or in their break between high school and college, they were involved in an unlawful detainer action, and so they didn't put that on their application. And now the Committee of Bar Examiners wants to know, why did you try to conceal this information from us? If the person corrects it and does an addendum or a supplement or a revision, the lawyer's not precluded from continuing to represent them. It's only if they seek to persist in the omission of material fact or the direct misstatement that it presents the ethical dilemma for the lawyer.
So my question was, you withdraw from the case, the court appoints a new attorney. The new attorney doesn't know anything about the false certificate that's in the file. So this false certificate is in the file
That's right.
as if it's genuine.
That's right. And that's the irony. That's the irony. And this comes up all the time. It comes up in conflict cases all the time. So the lawyer withdraws because ethically the lawyer has to withdraw. Client goes to new lawyer, doesn't tell new lawyer of the problem. The new lawyer is blissfully ignorant and goes on with representation. But it doesn't vitiate your duty not to continue with the presentation of fraudulent information once you know. And it's an irony. It doesn't really make practical sense, but that's still our duty. Yes.
What if, like, the client gave you documents that you didn't know were fraudulent, you presented them, and the department verified them, and they turned out to be fraudulent, but then the client never comes back, so that client's going to make it right? Do you get off? Should you get off, or what do you do?
Well, and in what way are you out? How did you get out of the case? What was the termination of the attorney-client relationship?
Okay, the guy never came back, so after I found out that they had been fraudulent, because the department verified and they said, well, this person is not a counselor here, has not been a counselor here. The client never came back to court for me to inform them that these were fraudulent, and that client never had an opportunity to withdraw them, and I've never had a chance to talk to the client about that because the client never came back.
Okay, well, it seems to me that in the situation where you don't know during your period of representation of the client that there were any misstatements or false statements, and you only discover it later, we're again talking about a past bad act. And so if you have no continuing involvement in that case,
No, I'm still on. They won't relieve you until the court either terminates parental rights or the court closes the case. So at that point, I could talk to my client and say, hey, these are not what you said they were, because my client never came back. So the court was not going to relieve me, and I couldn't go to the court and say, you need me because these are fraudulent. So what do I do?
well, again, if you have a continuing role as attorney of record for a client who you discover has put false facts before the court, then your duty is to go to the client and try to persuade the client to rectify the false statements. And if you cannot, then if your continuing involvement is going to perpetuate a fraud on the court, you should withdraw. And if the client won't allow you to withdraw, then you should make a motion and explain to the court that you have learned information in confidence that creates an ethical duty upon you to withdraw from representation. There really isn't any other advice. There is no other choice. You can either stay in the case, and if later it comes to light that the client, that it's based on false information that the client put forward, and the court finds out about it and sets an OSC, raise sanctions, or refers you to the state bar, and your response is, well, I just stood silent knowing that a fraud was being committed on the court, you could have ethical charges brought against you. So you only have two choices. One is get the client to correct it so that you know that the case is being determined on true facts, or declare a conflict and withdraw.
That's not what she said. I don't think that's what you, from what I understand, is she did not know that the information was fraudulent. The department found out, the department provided the information to the court, and then the client never came back.
I don't know, see, I don't know what you mean by client never came back.
We often have clients stop coming, but we are required to stay on the case.
Okay, I mean, but has the client disappeared?
Yes.
Okay. Okay. Disappeared, I think, and I would argue, as your defense attorney, if either a judge or the state bar tried to discipline you, I would argue that you had no, it's the theory of the axiom of impossibility. You have no ability to get the client to come forward and correct it because the client is gone. Now again, I strongly recommend that you make a record of your efforts to try to find the client. But if the client is gone and you can't find the client and there's no way to rectify it, I would feel comfortable arguing in your defense that it's a past bad act, it can't be rectified, you cannot come forward and reveal a client's secret, so you had no option but to stand silent, having made a good faith effort to locate the client.
So when they disappeared, then do we make a motion to get released based on that after we've done all those things?
Well, what's your continuing duty? What are you still doing in that matter after the client disappears?
I'm looking for notice, I'm looking for...
We're trying to do whatever their last request was.
Give me an example, like what would you,
I want my kids
what's
back.
that?
So we'll be appointed by the court at a detention hearing, and then our client will never come back, and we still represent them for a trial, for a disposition hearing, for a review hearing, up until their parental rights are terminated. And so my question is, how do you represent someone when you have no way of contacting them, and you're on a case for up to 2 years since your last contact, where their rights are still intact, being affected, decisions are being made that are adverse, then what are we supposed to do to represent those people?
Okay, is that your same, okay. So that seems to me to be the same situation that every lawyer is involved in when a client disappears. And it happens, I mean, for example, it's really common in personal injury law for clients to, who are not citizens but who are here when they have a car accident, to leave the country. And they don't tell the lawyer, and the lawyer can't find them. The lawyer has no idea where they went. So what you have to do is you have to make a motion to be relieved as counsel. And again, you have to do it in a way that you do your best, and it's not easy, but you have to balance not harming the client, trying to do it in a way